Self-defense has been around for ages, and it is used universally. Self-defense has been in demand not only now in modern times, but also in civilizations from the past. An example would be primitive self-defense. It is known to be an inhumane and very violent form. Towards the Middle Ages, more limits were being established. All subjects have the right to self-defense. It is characterized as a subjective right, type of legal activity, and a form of protection of infringement on someone else's rights.
One of the self-defense or stand your ground laws is called the Castle Doctrine Rule. This is the duty to retreat before using deadly force. Deadly force is the last resort, and leaving the situation to keep yourself safe is the most important. The law was named the Castle Doctrine Law since the one exception to this rule would be if someone is in one's home, which is referred to as castle. This law was expanded to cover any place that one has a legal right to be, such as one's vehicle or place of work. The main purpose of these laws was to provide freedom to self-defense victims and lower the rate of using lethal force to protect oneself. Depending on what state you reside in depends on whether these laws are in place and to what extent they are. Missouri, for example, is one state that eliminated the duty to retreat and allows the use of deadly force on private property where non-deadly force would only be allowed. Texas, for example, is one state that does not allow this.
In 2005, Florida became the first state whose no retreat law became characterized as a stand your ground statute. A person has no duty to retreat if either the person believes that such force is necessary to prevent imminent death or great bodily harm to him or herself or another person, or if they pertain to the use of force in the context of a home or vehicle invasion. When an intruder unlawfully attempts to enter, or refuses to leave a residence or vehicle owned or lawfully occupied by another person, the owner or occupant is presumed to have held a reasonable fear of death or great bodily harm so as to justify the use of deadly force. Florida's stand your ground law will not apply when a person is engaged in an unlawful activity or is in a place they have no right being. The law will also not apply when evidence establishes that the defendant provoked violence against him or herself.
4 years ago, the state of Kentucky held a meeting to update and educate residents about the stand your ground law. The state was concerned whether or not it actually was making the community safer. There is a big push on this because of the Zimmerman case in Florida. In Kentucky, the law states that individuals are not obligated to retreat from an attacker in the place in which they are lawfully present. The state's self-defense law was amended in 2006, and it states that a person can use deadly force if they believe it is necessary to protect himself or herself against the use or imminent use of unlawful physical force by the other person.
Stand your ground laws define that, under certain circumstances, individuals can use force to defend themselves without first attempting to retreat from the danger. Stand your ground laws differ from state to state and spark some controversy, including criticisms of encouraging violence and shoot first, ask questions later attitudes that result in more injury and death.
In Illinois, a person can use reasonable force to defend themselves, someone else, or their property. To use self-defense, there must be an imminent danger or a threat to you, someone else, or your property, and the threat must be unlawful, or you must have believed that there was danger that was existing. Your force must also equal the threat. Regular force can be used to defend against an attack or entry into a home, and deadly force can be used to prevent a forcible felony such as sexual assault, battery, murder, robbery, arson, assault, or the threat of violence against you, someone else, or your property, only if the entry was a violent one.
Texas self-defense law, like most other states, used to have a stand your ground law, but abandoned it for the Castle Doctrine. This states that in your home, vehicle, or workplace, you can use deadly force without attempting to retreat first. In any other public area, if proven that retreat was available, then the self-defense law would not protect you in a court of law. Self-defense is not justified if it was in response to verbal provocation alone, the actor resisted arrest or search, the actor flees the scene of the crime, or if the actor was carrying an illegal weapon.
In conclusion, self-defense is allowed and used. There are just different limits on it in different states. The Stand Your Ground law defines that individuals can use force to defend themselves without first attempting to retreat from danger, but only under certain circumstances. The Castle Doctrine, which is duty to retreat before use of deadly force. Deadly force is last resort. The only exception for this would be if someone is in one's home. In Missouri, they're different when it comes to the Castle Doctrine. People are allowed to use deadly force on private property. This is not the case in other states like Texas. And in Illinois, to use self-defense, there must be imminent danger or threat to you or someone else on your property. Different states have different limitations on self-defense, but you always have the right to it.